Then my lord, they were reproduced the याचिकाकर्ता द्वारा अपने आवेदन में उत्तरवादी त्रुटि के कारण आवश्यक एक उत्तरवादी दस्तावेज प्रस्तुत करें जिसके आधार पर यह अनुबंध तैयार किया गया है। अपने आवेदन पर समर्थन में श्री का शपथ प्रस्तुत किया। उत्तरवादीगण द्वारा अंतर्वर्ती आवेदन क्रमांक 4 उत्तर में यह कथन किया गया है कि याचिकाकर्ता द्वारा अपने आवेदन क्रमांक 4 के चरण क्रमांक 3 में अनुबंध इस मूल दस्तावेज से तैयार किया गया है, प्रस्तुत कर निवेदन किया गया है से कि याची उत्तरवादीगण के मध्य अनुबंध निष्पादित किया गया है। मूल दस्तावेज है जो कि अन्य दस्तावेज पर आधारित नहीं। याचिकाकर्ता जब निविदा तब निश्चित निविदा की शर्तों के अवलोकन किया होगा। उत्तरवादीगण द्वारा जो निविदा बुलाई गई थी उसकी निविदा आमंत्रण का अवलोकन करना आवश्यक है। निम्नानुसार कंडीशन I read one of these conditions. This one, contractor shall be deemed to fully satisfy themselves before the tendering into respective following correctness and sufficiency of the tender for the work, the description of the rates, terms, work, and all the rules given in the schedule of the rates and applicable of works, all terms, condition mentioned, tender form, and all other contraction form standard and procedure laid down in the National Building Code. Issue by the department gives standard of availability of materials, goods, plant, dwellings, good water, electricity required for work, potentially and available for site work. Production and maintenance of approach board there should be live fully in the contract. Market rate for material is required to be by all contract. उससे निश्चित है कि पूर्ण स्पष्ट है कि याचिकाकर्ता को निविदा पर प्रपत्र प्रस्तुत करते हुए पूर्व उल्लेखित सभी तथ्यों एवं शर्तों का अवलोकन ध्यान करना चाहिए। इसके अतिरिक्त याचिकाकर्ता द्वारा उत्तरवादीगण के मध्य अनुबंध निष्पादन पक्षों के उस अनुबंध को पढ़कर अक्सर करना चाहिए। निविदा आमंत्रण पर प्रपत्र 6.3 की शर्तों से स्पष्ट है कि all conditions mentioned in tender notice will be binding on the contractor in addition to conditions of the contract. याचिकाकर्ता को उस समय बात की आपत्ति नहीं दे सकते कि पूर्ण रूप से मूल्यवृद्धि के फॉर्मूले रोड कंस्ट्रक्शन एवं बिल्डिंग कंस्ट्रक्शन फॉर्मूला अंकित नहीं करता हमारे मृत्यु मुश्किल होती। तो these are the judgment they have mentioned. Then my lord in para 9 अनुबंध स्वयं में मूल दस्तावेज होता से किसी अन्य दस्तावेज के आधार पर बनाया गया है, वह दस्तावेज प्रस्तुत करने का कोई आवश्यकता नहीं, क्योंकि अनुबंध उभय पक्षों के मध्य हस्ताक्षरित होता है, प्रमाणित करते हैं। अनुबंध को पढ़कर अपने के पश्चात याचिकाकर्ता ने किए थे अगर याचिकाकर्ता को मूल्य वृद्धि के संबंध में दिए गए फॉर्मूला अनुबंध हस्ताक्षर करने के पूर्व उसे ठीक कर देते पर याचिकाकर्ता ने ऐसा नहीं करते फिर याचिकाकर्ता नहीं आई। These findings that have been recorded by the learner. बिंदु पर याचिकाकर्ता संतुष्ट अंतिम कर के दौरान स्पष्ट कर सकते हैं। मूल अनुबंध सत्य प्रतिलिपि प्रकरण के समय दिनांक स्वयं को प्रस्तुत की जा चुकी है, अतः इस पर आर्टिकल ये अंकित किया। हमारे मत में मूल अनुबंध दस्तावेज के आधार पर तैयार किया गया और दस्तावेज उत्तरवादीगण से मांगने का कोई औचित्य नहीं, क्योंकि उत्तरवादीगण ने भी अपने जवाब में उल्लेखित किया कि याचिकाकर्ता उत्तरवादीगण के मध्य अनुबंध बाधित हुआ है, मूल दस्तावेज है, दस्तावेज के आधार पर नहीं। उत्तरवादीगण अनुबंध के आधार पर दस्तावेज अधिकार प्रस्तुत करने का कोई औचित्य नहीं है। My application has been rejected. But my respectful submission, there is a judgment, my lord. It permits, my lord. And my lord, this finding has been recorded, my lord. This while deciding the order 11 would do application. There is no such argument has been advanced by the party. Neither the judgment has been cited by both the parties. These all the observations of the learned tribunal. And my lord, for that, my lord, in order to overcome this issue, my lord, there is a direct treatment of honorable apex court. Similar kind of mistakes are there. Similar conditions are there, my lord. This judgment I am citing.
Yeah.
This is my lord. National Builders Construction versus State of Maharashtra and others.
Citation.
And it is a 2018 13 ACC page 200.
Which para are you line?
Para 9 onwards, the findings are recorded to this effect. Evidence is required to be established if there is a mistake. That is the only. Has been answered by the honorable. And the mistake has been was interpreted in an objective manner, where one logical conclusion should be reached. Some printing mistake and that clause is also scored out. Kindly see, just mentioning it. The page 51 में kind it will start from page 50. As there is a layer of this blank has been written, then another page also the formula factor blank has been mentioned. Kindly see to follow the movement page 60 में kindly see whether it is a road construction work mandate page 60. The agreement, how the agreement has spelled out.
So in paragraph 10, this court has said that this matter is still pending.
Yes, ma'am.
You will have a right to agitate all these things for the tribunal.
Yes, ma'am. Those findings are not final, ma'am. This is that I want that should be observed, because the findings were recorded, that has not been argued.
You base all your contentions there.
So far, this agreement part is done. From where they have prepared this agreement,
you can always raise this contention there and challenge that there is some other document on which it is based. So please produce that document.
That is my application, that is precisely my application. Yes, my lord, these documents, kindly see.
Which is that document?
What? Just advance it one more thing. That is the Public Works Department manual. So for all the local bodies
that is available with you also.
Yes, very much available.
Where is it? Please tell us.
So, from where they have prepared all these documents, that is the only source in Madhya Pradesh. Because in 11C,
you want the original documents to be produced,
yes,
on which the agreement is founded.
Or they may clarify the position from where they have.
Now, you say that the original document is the manual.
From where?
Manual you also have. Manual is in public domain. Where is that manual? Show us.
But they have to clarify this position. The respondent and president both are saying this is the original and this is the binding manual. So where is the question of needing evidence? Every door has been closed by this order. See, what evidence I would lead my lord. If I want to establish as front of the honorable apex court judgment, there is a printing mistake. I have right to establish my lord. For that the material is required, my lord. So this very document, whatever they are having, what is the source of
that manual is available to you or not?
Well, manual is right now is not available, but it can be public document, my lord. It can be arranged, my lord. I am not disputing this.
You present that before the arbitrator. That this is the original document. Please compare.
That I
do it.
That I
You raise all those contentions.
I will base my.
Why to test this MP?
MP is the observation they have made. Kindly see the observation just before the operator.
Because you did not present that original document which was available to you and is available on the public domain. Yet you did not present it before the arbitrator. They may deny anything. They are your opposite party. You should present before that document that this is the original document. Please compare the agreement with this.
But the observation we all other paras they have made by law. Because it is neither part of my application nor their reply. The judgment nobody has cited my law. So many things they have mentioned my law in the order. So it is virtually my law dismissal of my reference petition. This is the order the tribunal has caused. So in the final last para they are observing like this. So definitely other paras would come in my way. And you see the judgment they have cited, nobody has argued my law. Not this judgment. The judgment which I am, it is just contrary to that judgment and situation. So these things would come in my way.
We'll say that that document which you are contending with the foundational document is available in public domain. And if you present that before the tribunal,
That may be observed.
they will consider it in accordance with law without being prejudiced by this order.
That may be observed.
Counsel for the petitioner. In the present petition assails the interlocutory order passed. Final order passed. Passed on so and so by so. I know, yeah.
In November 2007, in 107.
कुछ फास्ट करो तो एकदम wait. By which an application under order 11 rule 12 referred by the petitioner. Where is that application?
It's in a page, around P3 102.
Seeking production of original copy of the contract agreement. Which the petitioner contended to be the foundational document based on which the agreement in question was entered into between the rival parties. This application was dismissed by the tribunal. Tribunal's order is P5. Which was rejected by observing thus. Para 10 quote page 110. Next para. During the course of arguments, the learned counsel for the petitioner does not dispute that the foundational document sought to be produced by the petitioner by way of the said application and the orders is available in public domain. Next. In view of the above, this court, instead of entering into the merits of the matter, relegates the petitioner before the tribunal. Before the arbitration tribunal, that in case any such document which is contended to be available in the public domain as produced by the petitioner. Then the same shall be arbitral proceedings pending.
Pending.
So then arbitrator will consider
Take a look.
produced before the arbitrator. Then the same shall be considered by the, then the said request shall be considered by the arbitrator for whom the arbitration proceedings are pending, comma, in accordance with law, without being prejudiced by the order dated 2/11/17 passed by the tribunal in case number 36 of 16. P5. With the aforesaid observation and liberty, the petition stands disposed of.
And my argument may be, if my not my submission, my not that is not.
But the first one, the petitioner has pressed into service the verdict of the apex court in the case of so and so. 2018, volume 13, SCC 200. Para 7.
Look is connected.
9 onwards. Both the cases are same.
But I will argue in the next week. Separately, I want to argue next week. Some petition is required.
13.1 must be the same.
No, not same, different order. Different order. Nature of order is different. One poor judgment I want to fight. That next week we will take.
13, this is item number 13. I know that. अच्छा आगे तो क्या चार्ज है
इसमें my application filed under Rule 29 was rejected, my lord, for cross examination of the equitable. That
13.1
that I want to argue in the next week.
Learned counsel pays for adjournment to prepare the matter since he is not ready with arguments on admission stroke final list the month of all go.
Number 14, please check on service.
There is an application for condonation of delay in this matter. What is also required now? The final award is under change. Yes.
Yeah. So what is the matter?
But award of net journal is under change, there is a delay now.
How much?
Around 60 days now.
Just 7 days barred. Who is for the other side? State Council place foreign is granted. Time to file reply to IA. Seeking condonation of delay of so and so days in preferences revision. This January.
Number 15, Mohammed Wajid Haidar, Nancy Misra.
Yes, is the process of settlement underway? parties, tribal parties do not dispute process. How long do we keep this pending? How long do we keep this pending? This is under consideration since when?
Yesterday the price had offered on the price as me to prove my offer from 22.50 lakh to 23 crore.
And
I had given that.
What are you challenging? What is under challenge?
This is not
They are not challenging anything, they are seeking funding with the bank license for their settlement.
we additional
All the disposed of the
Still bank. It may be cash.
Same may be considered.
Let us see the prayer. All right, so we dispose it off. Recusement. The present petition has been filed.
Marriage my the colleague will come from Delhi to address your lordship. So for marriage discussion. I followed my offer is pending.
Is there to address on merits?
My
You are seeking a prayer which they are considering.
also will come from Delhi.
No, no.
He was there.
We dispose it off. At best, we can pass it over.
He has come from Delhi. So
What will he argue? Please tell us. What will he argue?
that scheme, OPS scheme of the bank is.
You say that please settle the issue. They are saying that we are considering the settlement. Why should we keep this pending? We will give you that liberty to come back.
If they reject my proposal, then it will be.
So we'll give you the liberty.
It will be sorted by way of amendment matter in this petition.
We'll give you the liberty to come back.
My council will address your lordship, which was come from Delhi. Therefore, I am seeking that nationally it will be hard. And that is actually
Find it out.
clear to the. For the funding.
The prayer made in this petition is for a direction to the respondent bank to accept the proposed compromise offered by the petitioner, along with peripheral release. Next, the bank, in the last 3 hearings, is in the process of considering the prayer of compromise. Next, at this juncture, this court has prima facie, this court prima facie found that in the given facts and circumstances, where the prayer of the petitioner is being considered, the petition can be disposed of without granting further time for the parties to conclude the settlement process. Next one. The learned counsel for the petitioner, Vajid Haider, submits that that an outstation counsel shall argue the petition on merits. Next one. To afford an opportunity to the outstation counsel to argue this the case day after tomorrow. Will you give us a date? Give us a date. It is next week. 18th is not next week. So we'll take it up on 12th. If he has a problem to come down, ask him to get connected virtually. 12th, just on 12th. with the understanding that no further adjournment shall be granted. The matter shall be decided irrespective of the presence of the council for the party.
Bill number 16, Sri Ashok Kumar Tiwari.
As they were in the evidence of the complainant as well as the evidence of filing. If their name was mentioned that they also took money.
Hmm.
To bring the complaint. This may not have been actually one.
Then what happened to the application?
That my application was rejected.
On the ground?
On the ground, not that he should not detect the side of evidence is not in. In fact, the evidence which is available on the contrary is not an side. The application was dismissed. That is saying that we never have.
So some of the material witnesses stated the name.
The complaint.
Where is-
PW6, I have filed a copy of the evidence of this PW6 with the complainant at page number 16.
Which is the prosecuting agency?
Local, no?
Okay, have you given a copy to the
Yes,
official?
advance copy was.
To whom?
Mr. September was.
It is informed by learned counsel for petitioner that advance copy was given to Shri Satyam Agrawal, who ordinarily appears for the Lokayukt organization. Next, let name of Shri Satyam Agrawal be reflected in the cause list. Next week.
All the copies were described. The appeal statement was also recorded on this.
Hmm.
Now the case is paid for 11 December.
Hmm.
For the evidence of difference.
11 December, then
Yes.
we'll place it day after tomorrow.
Yeah. That will be on Monday itself, no?
Or it's 11.
Bill number 17 with connected matters. Sri Manish Kumar Tiwari, Ajay Pratap Singh.
Item number 17 is 73 for charge. Pilots were being to work on the researches from the High Court. There was some interpretation. Item 3.6. I am strategy of points last. Thanks a lot. Everything is fine.
17.1. Page 17.1. There is a revision, there is an NCRC and a WPO. Why so many different kinds of cases?
For the application for bail.
Or
Bail.
bail, MCRC, that's a repeat bail. And WP,
Your Lordship, this is for quashing of multiple FIRs into club precinct.
and criminal revision is against
Against the charge.
Your
charge.
Lordship, these are, though they are from same crime number, they are not connected. So charge one and district thing.
They arise from the same crime number.
Crime
One
number.
of them.
That synopsis किसने पेश किया आपने? आपको बोला गया था क्या पेश करने में?
By order taken, taking the
That is not on record.
This case,
Adjusted है. इसकी तरफ से है वो. इसकी तरफ से है. Bank. Yes, बताइए. Then it will have to be taken up on some other day. January sometime. Bail we can hear. That is there in bail. Bail is fresh or it was listed earlier also?
Single matter. But now, this matter, that's all.
Well, no, I have the diary. Yes, बताइए.
Australia was withdrawn, then the selection issue came number 14. So, it has been not by the from the court of single bench order, but into the connected matter, this matter from. Well, that's what the case of the prosecution, it is amended.
Where is that earlier order of bail rejection? In one A2 क्या?
Case number 14.
A2. Is Rmpssu Mishra. Very short order.
It is withdrawn.
Withdrawn. This for withdrawn. So it was not considered on merits.
Yes,
What is A3, A4, A5, A6?
well, AC is the bail order for the this present applicant was being granted bail by the apex court and this on in another time. Several cases have been registered. In the case number 16, annexure 18, AC, and case number 20, these are two orders are the from the apex court one. On ground of custody that of 7 years and the application has been considered once. Another orders of are from page number 22 onwards, right? They are the bail orders. The applicant has been granted bail by the sound court. Page number 22, then at 25, 28, and 30 orders.
Who accused have been granted.
Orders are at page number 36. Page number 36, annexure 18, these are the orders of question. Page number 36, order of this Rashma Pachori, and page number 39 is the order of Srimati Gargi.
These are all government servants
Yes, sir.
or bank officials.
Bank officer.
And you are also bank employee.
Yes, sir. Well, as per the prosecution case, it is said that from the Scorpio vehicle of the applicant, about 60 months that has been seized forward. With cash. For the applicant has applied for Subala before the tax was ordered. That or now has been displayed thereafter. As per prosecution, the applicant has filed the revision order. The Subala was allowed order. Our prosecution alleged that the applicant allowed it as a requested process. But tried to justify the amount that been seized by him has been withdrawn from the bank, has done some manipulation at the backside of the check.
No, this co-accused are not all bank employees. One of them is a retired Jilla Sehkari. Acha. And you are in custody since when?
Custody में दिया है 13/12/2021. Apart from that, the applicant he is in custody since about 8 years. शुरू से जेल में तो release नहीं है.
That is in respect to another crime.
Another crime, किसी में bail होती तब bail होती तो तब fresh case register.
Similar nature.
आपसे सुनो सारा रामचंद्र के बारे में
The main accused यही है.
हमको बनाया 16 करोड़ डाला है पूरा सिनासिस में दिया है इनका कहा
तो इसमें ट्रायल में क्या पोजीशन?
बाकी इसका फाइनल प्रोसीडिंग नहीं है इसमें हम ऑलरेडी आपको साथ में उसमें मेल हो गई अटैच फॉर सेल्फ ग्रांटेड बिल मतलब बट क्योंकि दूसरी केस के अंदर इसमें इसमें रिलीज नहीं हुआ है दैट ऑर्डर इज जिसमें मेन एजुकेशन हमारे खिलाफ आया है तो उसमें ये दैट ऑर्डर इज पेज नंबर 16 वाला
इसमें चार्ज कब फ्रेम हुआ है इन दिस केस?
चार्ज आपको चैलेंज किया क्वेश्चन जब थे 28/9/22 that question are challenge is payment of charge order.
उसके बाद कितने विटनेसेस हो चुके?
उसको तो हमको वेट माइंड होगी जो भारत अपने पहले उसने रिजल्ट आया कि ग्रांटेड बिल दिस केस इज रिलेटेड टू प्लान नंबर 1 ऑफ 2021 और स्पेशल सिंबल मिस्टेक नहीं हुआ
हाँ, इसमें कितने विटनेसेस हो चुके? ये तो आप ही को बताना पड़ेगा।
स्टार्ट नहीं
स्टेज ऑफ ट्रायल क्या है? Because the charge was framed more than 1 year back. Trial must have begun.
but looking to the education
Main witnesses हो चुके हैं क्या?
knowledge नहीं थी और वेलफेयर हमने दृष्टि लेकिन बिजनेस होने ना होने सब आपको पता है कि कॉन्स्टिट्यूशन के समय इतना स्टैब्लिश पहला केस ही नहीं है इसमें क्या कर दिया हमने यूथ ड्राइव नंबर पता है इसमें क्या कर दिया 40 इयर्स तक
एलिगेशन बड़ी है इनके पर। एफआईआर में छोटा सा रेलेवेंट पोर्शन पड़ी इसके खिलाफ क्या है?
इंक्लूड ऑर्डर से पढ़ देता हूं
The impugned order may not reflect the right allegation. Let us see.
तो शॉर्ट में है वो क्या 61 लाख सीरीज में हमारे पास है तो इसने बोला सुपरमार्केट की जाना है कहने कि हमने ये बैंक से विड्रॉ किया था तो जो बैंक से विड्रॉ किया बैंक से तो विड्रॉ हुआ इसमें कोई डिस्प्यूट नहीं एक 20 लाख का चेक विड्रॉ हुआ 40 लाख का चेक विड्रॉ हुआ लेकिन उसमें डिनोमिनेशन में जो उसमें आते हैं कि 500 नोट इतने नोट 500 के इतने नोट एक के आते हैं तो उसमें इनका कहना है कि जस्टिफाइड कि हमने बैंक से विड्रॉ किया है कि जगह डिनोमिनेशन चेंज की है मतलब जैसे 20 लाख में विड्रॉ है तो 1700 लोग हमने 1000 के किए हैं और 500 लोग को जस्टिफाई करने के लिए 500 लोग नहीं विड्रॉ ठीक है दिस इज द है काइंड दिस इज द एजुकेशन कि इन बैंक में पीछे चेक के पीछे नोट के डिनोमिनेशन रहती है वो चेंज की
In how many other cases you have not been granted bail?
नहीं बाकी में अप्लाई क्लियर नहीं हुआ इसमें बाकी इसमें हो गई अभी फ्रेश है तो अभी में और एक्सट्रैक्ट करनी है
Main case कौन सा है? Crime number.
मेन केस 12 बन रहा है इफेक्ट ऑफ 71 ऑगस्ट 2000 मेन कंपनी इनका अलग अलग रोल सब में अलग अलग रोल
सब interconnected है सब।
ये नहीं होता सब में अलग अलग ट्रांजैक्शन हम तो कैश उसका एक अलग केस बनाया हमने कि उसका तुम्हें इतना कैश आप लोग रखें उसका एक सेपरेट केस है अब इन्होंने बोला कि हमने एफडी का नहीं
All must be tried together.
ये भी क्या है
Therefore, we define it.
ये सेपरेट अलग सब एक record
Series of acts. Independent acts.
Yes. Independent.
Each act cannot stand on its own legs without the support of others.
फॉर एग्जांपल प्रेजेंट केस में तीन केस बनाया प्रेजेंट केस में काफी अलग बनाया आपने जो दिया अलग अलग कि प्रेजेंट केस में ये वाला
एक synopsis तो आने दीजिए synopsis है नहीं. It synopsis filed by the state. Synopsis has been filed by the state, detailing mentioning the details of various crime numbers registered against the petition. It said synopsis has not come on record. Registry to place it on record. List the case in the next week. Next week.
Bill number 18.
तो हमारी $125. हमसे नहीं मालूम क्या भाई नाम से 20-5 सब्जेक्ट कराए गए थे। आपको कहना चाहिए उनको नहीं लड़ाई में नाम आगे में मालूम करना चाहते हम 125
ये फर्स्ट अपील किसके खिलाफ है?
ये पति
नहीं नहीं, किस ऑर्डर के खिलाफ है?
एक ऑर्डर है तलाक का तब्दील एप्लीकेशन
में क्या हुआ था? रिजेक्ट हो गई। किसने पेश करी थी? वाइफ ने।
फिर दूसरा पेश किया था।
और ये दूसरा एफए क्या है?
दूसरा एफएम बोला दृष्टि धन के वापसी के लिए कोर्ट ने बोला कि नहीं क्योंकि आपका तलाक नहीं हुआ इसका
ओके।
फिर उसके बाद दो एमसीआरसी फर्स्ट पेचिंग साहब ने पेश किया और एक कंग्रेस डिवीजन ने पेश किया है 125 कुछ कराना उनका मुझे अब इसकी कोई काफी नहीं थी।
ये तो सब हस्बैंड वाइफ एक दूसरे के खिलाफ लड़ रहे हैं, उसमें कोई सेटलमेंट का आप लोगों ने कोशिश करी?
हाँ हमने कोशिश की थी। उसके पिताजी ने बोला कि हम रिटायर होने वाला हूँ
साथ रहने की संभावना नहीं है। नहीं, ऐसा आपका कहना है, दोनों का कहना है?
हम तो रखने को तैयार हैं पर मेरी तरह की अचानक बात हुई है। हमने काफी से बैठ के और एक बार वो भी चाहती तलाक को बीच का रास्ता निकले।
क्या चाहती?
अभी मैंने फोन किया था तो बोले वो इलेक्शन इतना वो नहीं आ पाए कहीं प्राइवेट नौकरी कर रहे बोले आप इलेक्शन के बाद में कुछ तारीख देखिए मुझे तो आपके
ये विदेशी तो शायद हो चुका है, असफल रहा है। नहीं हुआ है अभी।
नहीं विदेशन नहीं हुआ है लेकिन ये तो कह रहे हैं ना कि कहीं प्राइवेट जॉब कर रही है। अब उसने मैंने फोन किया तो यहाँ पर आने के 18 को बोले मेरा अकाउंट में भी इलेक्शन ड्यूटी है कल से इलेक्शन ड्यूटी खत्म। तो आप इसको इसी तरह से आप दिसंबर ही कभी लगा दें।
तो उसमें अगर मीडिएशन में नहीं गया तो एक बार भेज के देख लेते हैं।
और हम कुछ तारीख
तो अभी ना आ जाइए, 9 तारीख को नेशनल लोक अदालत है, हाईकोर्ट में आ जाएगी दोनों जने। मीडिएटर्स बैठेंगे, यहाँ दो चार मीडिएटर्स रहेंगे।
जॉब कर रहे हैं
125 में आपको समस्या आई?
125 में समस्या है वो नहीं जा रहा है वो चल रहा है
Contractual. Yes, the Learned Council for the rival parties, after seeking instructions, have agreed to explore the possibility of settlement. Let the rival parties personally appear.
इलेक्शन में ड्यूटी लग रही है इसका मतलब है कि प्राइवेट जॉब तो नहीं है। प्राइवेट कई लोग लगे हैं
Let the parties physically appear before the mediator on 9th of December at 10:30 in the High Court premises. Ninth. 11 बजे करो, 11 बजे 11 o'clock. हाँ
Bill number 19. Shri Sanjay Kumar Patel.
क्या हस्बैंड को रिप्लाई पेश करना था सेक्शन 24 के एप्लीकेशन? अपॉर्चुनिटी तो पहले मिल चुका है आप। नहीं तो उसमें लिखित में कुछ तो दीजिए। भाई 24 की एप्लीकेशन इन्होंने इन राइटिंग दी है, आपको भी इन राइटिंग उसका जवाब देना चाहिए इन द राइट फॉर्मेट जो सुप्रीम कोर्ट ने डिसाइड किया। The learned counsel for the husband respondent is foreign is granted for the 3 weeks time to apply with order 20th of November 23, list in January. It is made clear that no further indulgence shall be granted to the husband. And in case no reply is filed, then the application of the wife under section 24 shall be considered without the reply.
नाम बताएं।
Bill number 20, the RC unanimous to be attached of six.
ये MA किसके खिलाफ है? इसमें लास्ट टाइम में कोई नहीं आया था, क्या ऑर्डर हुआ है इसमें लोअर कोर्ट से? नहीं, नीचे विच ऑर्डर इज अंडर चैलेंज, क्या ऑर्डर हुआ है वहाँ?
नीचे ऑर्डर ये हुआ कि जो मालक है वो दादा के पास सकता है, फादर की मना कर दिया।
फादर की एप्लीकेशन रिजेक्ट हो गई। तो विल पास इट ओवर, नोबडी केम लास्ट टाइम, इस बार भी कोई नहीं। आप रिस्पोंडेंट के लिए पास हो।
Bill number 21, the Manoj Kushwaha, Vishnu Kumar Patel.
All right, please. Counsel for the appellant wife raised foreign and granted time. Respond to the delay condonation application. नहीं, delay condonation तो आपने लगाया। File a fresh application for condonation of delay. हाँ, all right. Another last opportunity is afforded to the appellant wife. In the interest of justice, comply with order 4723, just in January.
Bill number 22, the Mukesh Kumar Mulathi, Aritos Trivedi.
जवाब आप किसकी तरफ से? हस्बैंड। हस्बैंड के पक्ष में डाइवोर्स पर डिक्री हुई है। आपका स्टे एप्लीकेशन का क्या हुआ? पेंडिंग है। So till the time you file a reply, don't remarry. The learned counsel for the respondent husband prays for and is granted time to file reply. Reply to what? Stay का the application to stay 16202 of 22. Next one. This is the case in January. And the next date of hearing is the husband is restrained from remarrying.
Bill number 23, Sri Hemantrao Naidu, Naveen Kumar,
You are for the wife. Wife is challenging what?
Ex-party, हमारे खिलाफ ex-party divorce हो गया.
It's party में 9/13 फाइल करिए आपने application. You do that, why don't you do that? इसमें you will get opportunity to adduce evidence also.
और भी पता लगा कि इनका कुछ फाइनल सेटलमेंट भी हो गया है. तो उसके आधार पर अगर ये बैंक की आवश्यकता नहीं होगी तो हम इसको विड्रॉ करके वहां
Current counsel for the appellant wife pays for a short adjournment to find out as to whether the wife wishes to prosecute this appeal or not. This next week.
Bill number 24,
that Michelle the last order on 11/23. My lord had a specific order. It makes clear that the state does not have replied.
थोड़ा सा भी लाइट कनेक्शन आते हैं कैसा उठा दो उसको.
Even the father without the state and by
certain documents need state required to be filed. That filing the file copy has been supplied to the
It has been filed.
no supplied. Copy has been supplied to them. The document number has taken the second week of January for.
What is the matter about?
May I intervene in between? This is a matter which you must have heard. For the final disposal also that the B.Ed degree holders cannot continue in service.
So that's Dinesh Sharma's case.
Yes, my lord, that Devesh Sharma's case. Now the state, my lord,
Stands resolved now. What remains now? By that judgment.
yes,
It's only the question is only whether the B.Ed appointees should be out or not.
Yes,
That's all.
that's all.
So please argue on that short point. Let us finish it off.
It's very important thing, Lord. This Bhagwan Krishna case, Lord, they have referred to. That all consequential orders, for instance, will also stand nullified. Now, Lord, that Bhagwan Krishna's SAC copy I have taken from the Supreme Court, which I will be going to this honorable court shortly. Lord, that was the only point, Lord. And in Bhagwan Krishna was the only Lord point on which they were harping that all consequential means your appointment orders. No, that is not the point, not in Bhagwan Krishna's case. The point was that advertisement selection process which was being commenced are quashed. Otherwise, the action taken already, Lord, is fully covered by the Devesh Sharma itself. So that was being
you are for the
by the petitioner.
You are for the diploma holders or degree holders?
I am degree holder. Degree holder. I am supporting the state, my lord. And
So what does the state want? What is your stand?
Justify the action of the agency. But the rules wherein the rules promulgated by the state were never ever challenged either before the Rajasthan High Court or the Supreme Court. So we acted in bona fide, we acted in accordance with the rules. That is our standard of, therefore, all the subsequent actions taken in pursuance to the rules, which were valid and are still valid at all points of time.
You want the B.Ed appointees to be protected.
Arguments to be addressed by the Honorable Architect. By taking suddenly to January.
Well, subject to the other side agree, no problem.
I'm sure they'll be. Probably.
My lord, the return of this.
My lords, the return of the state
What is
government.
the interim relief granted?
But the interim relief was that when initially the advertisement was issued and the rules were put to challenge, your lordships passed an order that it would be subject to the final outcome in Devesh Sharma's case.
Subject to final.
Now, after the Devesh Sharma's judgment, my lords, wherein the notification issued by the NCT was held to be bad in law, the appointments orders, my lords, so issued were to be declared illegal and were to be quashed because the NCT notification stood quashed being in violation of Article 21A. That is right to quality education.
Devesh Sharma, if I rightly agree, remember, arises from Rajasthan High Court.
Yes, my lord.
Yes.
So Rajasthan High Court also there were rules, state rules there.
Yes.
In Rajasthan High Court, my
Same
lords,
as Madhya Pradesh.
To the contrary.
We had the rule.
No, same as Madhya Pradesh or different?
No, different. The Rajasthan High Court.
as I was the counsel who challenged it before the Rajasthan High Court. Let me place the correct position. What has happened in Rajasthan High Court? There were two petitions filed. One by the B.Ed degree holders, where they sought that they should be declared.
No, let us consume time in this case if it is being argued today.
My lord.
May I just inform my lord?
There's a prayer from the side of the state that the Advocate General will address. So if the other side agrees, we can place it on some other day.
I think, Lord, the response of the respondent, the official response is very important. And what the official respondents are doing, Lord, those who have not done B.Ed and have been appointed, they are being sent for for training. So my life is better. Whatever it may be, Lord, the state government is very important.
And the state was last time given last opportunity to file the reply till 28 miles. From the first day, from 1 year, they didn't file the reply. We were making a request that they will not do so because they want to continue these illegal appointees because they are the babies of their own rules. Now, in that circumstances, my lords, no more accommodation can be given to them once this rule of the NCT, the notification of the NCT has been declared to be in violation of Article 21A. Because ultimately, my lords, those children who are there in the school have to be taught with the quality education, quality teachers. The state can't take up this, that no, will continue with these persons who are not even trained for primary teachers. This is what was the basis was before the Honorable Supreme Court. They can't continue for a single day.
No, the Honorable Supreme Court is absolutely clear that the actions taken already in compliance with the rules which were not declared ultra-virus till the date of the judgment of the Supreme Court. No disturbance will be done. And my petition misrepresented to this Honorable.
Mr. Rupra, normally in such cases, where ultimately the appointment is found to be bad or something, we try to protect the appointees. The court, the intention of the court is always to protect. But here is a situation that if we protect, then we'll be allowing people who are not holding that qualification prescribed by the mother body. That is the NCT. Now that is a little problematic.
And appointments, my lords, were given after judgment of the Honorable Rajasthan High Court. It was an India question of the notification. There was no stay by the Honorable Supreme Court. Honorable Supreme Court observed that all appointments.
Sharma itself.
So anyway, please agree on the date.
Yeah.
Should it be on what date?
I only want the state government stand to reach the record. That's all.
Because that supports you.
That's my total anxiety. I don't want any. I want the matter to be argued tomorrow. No problem. But
It may be taken up tomorrow, my lords, or day after tomorrow. It may be taken up on 7th because ultimately the Honorable Supreme Court is quite
also.
My lord, to cut short the controversy, my lord. Honorable Supreme Court.
Similar case pending, Lordship.
Just give me 2 minutes.
Supreme Court clarification के लिए कि Devis Sharma एक judgment
There is an application filed in the Honorable Supreme Court seeking clarification of the Devesh Sharma judgment.
28 quarter Lordship. Kindly see Lordship.
क्या हुआ है उसमें?
Lordship,
The matter was heard by a bench.
रिफर किया गया कि ये डिसाइड करेंगे कि वही बेंच कौन सी बेंच इसको सुने Lordship 28 quarter Lordship. सिर्फ सुनिए कहा गया कि जो 11th ऑफ अगस्त का जो ऑर्डर है उसको जस्टिफाई किया जाएगा, उसको क्लैरिफिकेशन लगा हुआ है कि जो इस ऑर्डर उस डेट के पहले जो अपॉइंटेड हैं उनको बचाया जाए या क्या किया जाए, किसकी 11th दिसंबर को टेंटेटिव डेट रखी.
So similar SLPs were withdrawn. One was dismissed. We have already provided those orders on record.
So it has gone to the same bench.
It has been referred to the same bench for consideration.
So when, listed when now?
It is tentative date is as of now is 11th of December, but we don't know because the same bench has to be
11th of December.
the same bench has to be constituted by the orders of the Honorable Chief Justice of India. So that is why the issue here is quite the same. This is a result of West Bengal. The issue here is whether the people who already been appointed or the selection process was in process, whether they can continue to be in service. So for that limited issue, this has been referred to the same bench of the bench which had passed the Devesh Sharma judgment. Because in Devesh Sharma matter, there were a large number of writ petitions where appointments were also challenged. So the Devesh Sharma judgment did not interfere with that. The appointments already made. That was limited to the rules. The rules were struck down, right? So far, so good. But the appointments already made in the states of West Bengal, UP, Bihar, they were specifically challenged by way of writ petitions, 3 separate writ petitions, which are mentioned in the Devesh Sharma judgment. But they were the relief of putting them out of service was declined, was not granted by the Supreme Court in the Devesh Sharma judgment. So another clarification application has now been filed, which is now under consideration. Because this is one, there is another writ petition also filed from the state of UP. There also there is a challenge to the persons already continuing BEd people who've been appointed. That is also likely to be listed soon. So the matter is squarely engaging the attention of the Supreme Court as of now, my lord. So my respectful submission would be, my lord, may consider it appropriate to await the final education.
May I make it very much clear? A statement should be very, very correct on this aspect. Here the appointments were made subject to outcome of Devesh Sharma. May I submit, my lords, one aspect?
April 24. April 24. उसके पहले डिसाइड करेंगे. So all right, since it is listed, so let us wait for that. Posted in January.
The SLPs which were filed were withdrawn. There are the orders which we have placed on record. Those SLPs against the clarification orders were withdrawn. That order has not been placed before your lordships by the respondents.
No, that order that they have shown has been withdrawn. That case has been.
No, not at all.
SLPs were withdrawn, which were listed.
No, well, that is totally different. That is our 7th phase.
I provided those subsequent orders. That these SLPs, after being argued on 31st of October 2023, were withdrawn. I'll just read out that. After arguing for a while, learned counsel.
Just a minute. This case of Arnab Ghosh versus Union of India is Tentative date is 11/12/23.
Yes, ma'am, that is what I submitted,
That is arising out of Kolkata. There is another judgment which went from Chhattisgarh. There the SLPs were to be listed before the same
But
time.
the point, Mr. Counsel, is the same.
exactly the same.
There the Honorable Court dismissed there that no, we will not interfere whatever order we have
My
passed.
friend is wrong.
And in
There the
Madhya
appointments
Pradesh,
have not yet been
then
made.
here what
In
has happened is
Chhattisgarh and Bihar, the appointments had not yet been made.
that
That is
they
why
moved
the
an IA. Mr. Devesh Sharma, who is one of the applicant here, moved an IA before the Honorable Supreme Court that my appointment is subject to the Devesh Sharma's judgment. There, after hearing him, the order was passed that the notification stands quashed. The appointments were made subject to outcome of Devesh Sharma. Now,
Right.
once
Yes.
it was the applicant, all 710
this,
applicants.
No, this Arnab Ghosh's order, this case of Arnab Ghosh arises out of which High Court?
West Bengal, no High Court, my lord. This is a clarification
direct
application
petition.
filed directly before
It's
the Honorable
directly
Supreme
filed
Court.
in the.
Directly
Yes.
before the Supreme Court seeking clarification of the Devesh Sharma judgment.
Well,
So how can my lords, other states will affect when Madhya Pradesh there is already an order that would be subject
It's a
to
legal
Devesh
issue.
Sharma.
How Rajasthan will affect us?
Tomorrow
How
there would be a
Rajasthan will
person
affect
from
us?
Tripura, another would be from Gujarat, then would be from Himachal. We have
No,
28 states.
that basic cases, what is the name of the
Devesh
person?
Devesh Sharma.
Devesh Sharma from Rajasthan.
Well,
There,
that,
my lords, these candidates respondents moved an application for implement.
all right, it is brought to our notice that Devesh Sharma versus
Union of India.
Union of
Union
India.
of India, decided by the reviewing bench of this Apex Court on 11/8/23, was decided on so and so, full stop. In regard to the said case, what is this? A miscellaneous application 2206 of 23 has been filed by one Arnab Ghosh, seeking clarification from the Apex Court. Which is tentatively listed on the 11th of December. Next one. Let this case be taken up in January or hearing on any Wednesday, Thursday.
Grateful to my lord.
So, my lords, these persons will then continue in service despite the fact that they are not even trained. Now, a simple moving of an application, my lords, which has not been even entertained, will take away.
Let the Apex Court decide. If they take time to decide, or they don't decide, or they dismiss it, then of course we hear you.
It's a bench is still not being formed, my lords. The bench may not be formed. It is not for the court to take up a clarification application. Why? How can the court be forced to take up a clarification application? It's not by way of an appeal.
Mr. Counsel, they have said that it should go to the same bench. Now,
After that, my lords, the similar matters, the
so-
same bench
so the
heard it and
same
dismissed it.
bench, in all probability, will either be constituted in December or January.
My lords, then it
That's
may be
all.
observed that if no steps are taken up before the Honorable Supreme Court, the matter would be heard finally here. Otherwise,
It is not in the hands of the petitioners.
We have listed in January, we'll take up the
That's
matter
what
as
said,
the situation arises.
January. But today, if this position is not clarified in January, again they will take up the same plea that it is still pending. So that may be
What will
clarified.
happen in the
absence
Supreme
of
Court
any
on the next
clarification.
date of hearing? My learned friend wants that this honorable court should an advance rider on
It's
that.
not about this Honorable Court.
He is
It's
arguing.
about why
And
this
my
person
lord,
should
the
continue.
petitioner is guilty of giving reference to wrong orders, not giving wrong interpretation, which I have found out, which I will point out on the next date of hearing.
Then he would have argued it on merits today itself. My lord, if he is so confident that the interpretation as given by the Honorable Supreme Court stands in his favor, then why are they
Passing of the order.
seeking
Passing of
adjustment
the
of this
order, is
aspect?
there any point for discussing this?
Specifically, मैंने already job कर रहे हैं petitioner.
So it may be
We'll
clarified.
hear all of you in January. We'll hear all of you in January. Yes, yes, I have nothing earlier, shall consider.
Intervenor application has also been filed in 18/2/9.
In which case?
You want to WP 595/2020. There is a two intervenor application.
No, 24 point.
It is 17/376. And the second one is 18/2/29.
It is 24 point what? The case
24.1, you know.
1.
Nitin Kumar. Nitin Kumar.
What is the, you are intervening on behalf of?
On behalf of the BEd candidate, the who
BEd
already got the appointment.
BEd appointees.
Yes, yes, yes.
And this,
Who are working as an teacher.
and this Vipin Kumar Dwivedi's petition has been filed by?
But it has been filed by the BEd candidates who were challenging this particular notification for the passing of the notification, and also was to get done the 6 months of which course before giving any
So
job.
the petitioners and you are sailing in the same boat.
No, you're not. So I am the respondent. I just want to be in the respondent. I want to support the state that we are.
You are BEd candidates.
Yes, you're
BEd appointees.
Yes, you're not.
The petitioners are also BEd appointees.
Petitioners are the BEd appointees. Two of them, the petitioners are working, are doing the job in that, and one of the petitioner has not got the appointment in that particular case.
How can you intervene in support of the petitioner? Cannot
I'm
be.
not intervening in the support of the petitioner, Your Lordship. I am in against the petitioner. That petitioner is basically challenging that particular thing, that cancel the notification and the appointments that have been made after arising out of that notification. And we are the person who are into the are holding the particular job, that particular appointments which has been made after the notification has been arrived. And we are the candidates. We are the currently primary teacher appointed as a primary teacher. We are the BEd candidates who are still working, who are holding the job.
But you don't have a diploma qualification.
No, so we are holding the BEd.
BEd. Yes. The petitioners are also holding BEd.
They are the BEd. They are not holding any BEd. They are the BEd candidates who are challenging that the BEd candidate should not be appointed in the primary teacher.
All right, so far as 20, so far as IA, 24.1 है.
24.1, Your Lordship.
So far as IA 17376.
And 18.229, Your Lordship.
Both are by BEd.
Yes, Your Lordship.
Candidates.
Yes, Your Lordship. Both of them are the BEd candidates who are presently.
Who is appearing here? Who is appearing in this 24.1 for the petitioner? ये आप कौन है petitioners?
BEd diploma.
Diploma holder.
सभी petitioner जो हैं, जितना भी bunch है, सब BEd वाले हैं. BEd वाले.
IA so and so shall be our interveners who are all BEd qualified appointees. Full stop. The said IAs, the interveners in the said IAs shall be heard at the time of hearing of the petition. IA stands disposed of. Both the IAs stand disposed of.
One more I 166.
In which case?
13768 now.
Already order हो चुका है क्लास डेट की
The order हो चुका है? Then why are you pressing the IA?
You know, these two IAs are not being placed at that time.
Are you appearing for him? When the order is already passed, why are you pressing this IA?
This specific order, all the pending IAs intervene applications in the connected matters shall be taken up at the considered on the net data period.
और इसमें 24 में IA 16650 same application, same order. Now what is this IA 17472 extension of time? So has it been disposed of? The reply is filed. No, you have filed reply. लिखे 24 में, since reply has already been filed by the state today. IA 17472 of 23 so and so, having become infructuous, is dismissed as.
Madam, one more IA there, IA number 16883. Madam, for which the senior council is appearing for BC.
What is this IA? Application for implement 110. Implement of, implement of,
Implement of additional parties, we have the interview of the.
Who are you?
Through BC.
Who are you?
These are also BEd people, BEd candidates.
Interveners.
Interveners,
What interveners? What class of employees?
BEd appointed teachers.
Appointees.
They have the BEd degrees, and on the basis of that, they've been appointed. And
This is in 24.1.
24.1.
इसमें should be made you as a part. You asked yourself to be made party.
He may be heard. That is all we want.
You want yourself to be made party 110.
Yes, we want to be made parties because our appointments are under question eventually, because the final education would affect our livelihood.
All right, IA लिखे. IA 110, IA 16883 of 23. It's filed by how many interveners? How many persons? 71. 71 persons who were appointed, who are BEd qualified appointees and are opposing the cause of the petition. And apprehend that in case the petition is allowed, they may be ousted from service. So considering the aforesaid, the IA stands allowed that the 71 persons, as mentioned in IA so and so, being pleaded as respondents so and so to so and so.
Grateful.
10 days. Yes.
Number 25. Rohit Paneja, Mukesh Kumar.
IA to consider. Please, Mukesh Agrawal has entered appearance on behalf of the respondent authority and prays for time to file reply. So what reply will you file? Record, I guess.